Senator Schwartner, you're recognized on committee substitute for Senate Bill 207. Suspend the regular order of business.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business, take up and consider Senate Bill 207. Members, this bill concerns the paid or incurred statute currently in place and the reform of the paid or incurred statute. In 2003, the legislature passed House Bill 4, the Tort Reform Bill, which included a one-sentence statute governing how medical costs are presented in civil lawsuits. This law, the current law, provides that recovery of health care expenses is limited to the amount actually paid or incurred by the plaintiff, commonly known as the paid or incurred statute. However, to avoid the limitations of the statute, some enterprising attorneys have colluded with cooperative healthcare providers who wind up overdiagnosing, overbilling, and overtreating, thus skewing the final medical cost judgment in the case. These lawyers are able to present inflated bills to the jury, thus inflating the value of healthcare treatment and, secondarily, the value of the case overall. Further, Chapter 18 of the Civil Practices and Remedies Code allows a plaintiff to prove the reasonableness of these inflated charges and the necessity of services through an affidavit process. A defendant may contest with a counter affidavit, but unfortunately it is often a futile effort. Many courts have struck down the defendant's counter affidavits on various grounds, leaving the defendant unable to contest the charges or the needs for the services at trial. All of these factors have led to a fundamental unfairness in civil trials with medical damages. Members, this bill addresses the presentation of medical evidence at trial by proposing to amend the paid or incurred statute and the medical affidavit statute, thus rebalancing the scales between plaintiff and defendant. This important bill is joint authored by the three physicians in the Senate, as well as being authored by Dr. Bonin in the House. I believe it is a fair consideration between plaintiff and defense, as well as the healthcare providers attempting to make the injured person, whole. Members, at the State Affairs hearing on this bill, we heard from doctors and facilities who were concerned that the notice of intent to controvert would be abused by defendants. It was argued that this would force providers to participate in pretrial discovery and testify at trial. And to address those concerns we heard at committee, I will have a floor amendment. Mr. President, I move to suspend the Senate's regular order of business, take up and consider committee substitute Senate Bill 207.
Senator Hinojosa, for what purpose?
Will the gentleman yield for a question?
Yes, I yield.
Senator Schwartner, I think I do understand the issue in terms of inflated medical bills and there's a protection, and it is an issue. But my question pertains more to some of the concerns that have been expressed to me by hospitals in terms of the discovery aspects of a case where they're not a party to the lawsuit. How are you planning to address that?
Right. And that was what we heard in committee, the concern regarding undue amounts of discovery that would be required by certain healthcare providers in the case you're mentioning, hospitals. And to address that, there will be an amendment to the bill that would provide some guardrails. And if they fell within these guardrails, which is 150% of the workers' compensation amounts, that they would be considered fair and reasonable and therefore not be subject to discovery or further litigation procedures by the jury and by the legal system.
And quite frankly, as we know through civil litigation, a plaintiff or a defendant can bring any other party into a lawsuit as a third-party defendant, whether they like it or not. That's just the nature of the civil justice system that we have in place. But thank you for addressing my question and trying to focus on the issue of discovery and dragging in non-party people like and businesses like the hospitals. Thank you.
Thank you, Senator.
Senator West, for what purpose?
Just a question of the author.
You yield?
I yield.
So, Senator, as it relates, could you just briefly go back over the bill again and what the policy purpose is of the bill?
Right. Right now, there's a statute called the Paid or Incurred statute, which allows for the presentation of medical expenses in civil litigation.
Right.
Oftentimes, the currently worded medical statute allows for the overestimate, overbilling, overcharging, and thus inflating various verdicts, medical expenses, as well as the overall verdict in a civil litigation suit. This bill reforms the paid or incurred statute in current law. I can tell you how it does it if you'd like to go into it a little bit more.
Yes, I would.
Sure. The bill provides that if plaintiff's health care bills have not been paid, the jury will hear any evidence that has a tendency to prove the fair and reasonable value of the necessary services provided to the plaintiff. So a fair and reasonable standard versus a paid or incurred standard. The bill also changes the portions regarding the medical affidavit, counter affidavit process to allow for a notice to controvert rather than the requirement of a counter affidavit to be filed when the defense wants to contest the medical expenses that have been incurred by the injured individual in a civil litigation.
Those are the two issues right there.
Those are the two issues, yes.
So in terms of the latter one, the defense no longer has to file a contra affidavit?
That's right.
Why is that?
Currently, the filing of a counter affidavit oftentimes has to be done within a certain time frame that is difficult for the defense to perform. Also, the counter affidavit is, from my understanding, talking to various individuals involved in this, has fairly little weight in the judgment of various judges in Texas. And the de facto filing of the affidavit by the plaintiffs is taken into account and given full weight, but the counter affidavit on the part of the defense is given little weight. Thus, the imbalance between the plaintiff and the defense in the decision as to what is able to be discerned and judged as reasonable medical expenses.
But you're under the impression that the judge makes that determination? You're under the impression that the judge makes that determination, or the jury?
The judge, regarding the counter affidavit, yes.
Would it surprise you that the counter affidavit is given equal weight by the fact finder in the case?
That's not my understanding regarding how it happens in the current process of civil litigation cases. This counter affidavit is often not given due consideration, and therefore the bill changes a counter affidavit requirement to a notice to controvert instead of a counter affidavit.
Okay, and in terms of the notice, that means that the defense during the trial can controvert, put on evidence at that point, correct?
That's right. They're giving notice that they are going to give evidence that regarding the reasonableness and necessity of the medical expenses that will be in opposition to what the plaintiff has presented.
So, would it surprise you that under the affidavit process, each side is given notice of what the other side plans to do, or their position on the reasonableness of the medical expenses? And then the way that you're trying to reform it, I believe, is that you then will be in a position, and I think Senator Hinojosa mentioned a second ago, where you will require additional discovery on the part of the plaintiffs. Is that what?
The affidavit, counter affidavit process has been abused regarding civil litigation cases and medical expenses in particular, and what is considered fair and reasonable charges. This bill changes that and changes the counter affidavit to a notice to controvert those charges, so that they can present evidence to the judge and jury regarding what is fair and reasonable regarding those charges. Because of what was brought up during the committee hearing, and the necessity potential or the potential for discovery and undue legal proceedings on the part of various providers, hospitals, or physicians. I added to the bill that if they fell within certain guardrails, those charges, which are, if they fell within certain guardrails, 150% of workers' comp, then they would be considered fair and reasonable and would not be subject to further proceedings in the legal system.
Okay, but I disagree with the policy behind the bill, so I'm going to be voting no on the bill. I appreciate you explaining it, though.
You're welcome, Senator.
Motion is on suspension. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham.
19 ayes, 12 nays. The rules are suspended. Chair lays out in the second reading. Committee substitute for Senate Bill 207. Secretary, read the caption.
Committee substitute Senate Bill 207 relating to recovery of medical or health care expenses and civil actions.
There is an amendment. Secretary, read the amendment.
Floor amendment number 1 by Schwartner.
Senator Shorten, you're recognized.
Thank you, Mr. President. This amendment provides a safe haven for providers who treat accident victims by providing them or protecting them from being forced to participate in litigation. It accomplishes by providing that the defense cannot challenge the reasonableness of the medical charges if the provider's charges fall within certain parameters. And those parameters are the amount actually received in payment or 150% of the workers' compensation rates or less. If the provider or facility charges fall within these parameters and they state they do not intend to testify at trial, then the provider or facility is exempted from pretrial discovery and from testifying at trial. Finally, the amendment also makes some technical clarifying corrections to make it consistent with the House version. I'm happy to take any questions regarding the amendment.
Any objection? Hearing none, amendment is adopted. There is an amendment. Secretary, read the amendment.
Floor amendment number 2 by Lucio.
Senator Lucio, you're recognized on your amendment.
Thank you, Mr. President. Senator, you said this bill's purpose is to regulate runaway lawsuits and extremely high billing. I don't dispute some of that. I've seen it over the years. Most lawsuits do not involve the bad actors we're trying to regulate. I fear your amendment does not go far enough, as the rates are so low as to not allow for all reasonable claims. This amendment helps us use a more targeted approach by only going after lawsuits over $25,000 and helps us not overburden our health care providers. My main concern, Senator, is our hospitals that obviously carry a lot of burdens. During COVID-19, I've seen them champion many causes, not only in the Valley, but all over the state. Doctors like you champion many causes, and we're grateful. I don't want them overburdened with discoveries of X number of amounts. I mean, endless discoveries that could take place. So I'm offering this amendment and with the hopes that you consider, accepting it and make sure our hospitals and our healthcare providers are not overburdened.
Thank you, Senator. I appreciate you offering the amendment. Unfortunately, I will have to oppose the amendment. I believe I've addressed the issue of discovery and the potential burden on hospitals and healthcare providers with the prior amendment that I offered and authored as well. That provides a safe haven if they fall within 150% of the workers' compensation rate. The amendment as proposed that you have proposed, Senator, would have put a certain statutory amount, $25,000, that they would fall within, and I think that would be have to be potentially addressed in the future by the legislature And so because it's already been addressed and because I don't like putting a specific dollar amount, although I did consider that, and other people have proposed it, I believe the way it's handled, because workers' compensation rates actually will change with time and potentially go up with time, I think that's a better way of addressing this issue of discovery and the potential burden of discovery for our healthcare providers. And so for those reasons, I respectively will have to oppose the amendment.
Thank you, Senator.
Questions on the adoption of the amendment? Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
12 aye, 18 nays. The amendment fails. Senator Swertner, you're recognized for engrossment.
Thank you, Mr. President. I move passage to engrossment, Committee Substitute Senate Bill 207.
Secretary will call the roll when ready.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
19 ayes, 12 nays. The bill is passed to engrossment. Will hold there till tomorrow.
Thank you. Thank you, members.